Court does call the cases of the people versus Montel Gatlin.
Assistant Public Defender Ben Denowith on behalf of Mr. Gatlin, who is entering the courtroom now. Mr. Gatlin, would you state your name for the record, please?
Montel Gatlin.
Your Honor, at this time, the defense will refer Mr. Gatlin to the Forensic Center for competency. On both cases, I will email the form to the clerk of the court later today.
Buckle up, guys. Today we're going to the opening seconds of this tense courtroom day. The judge formally calls the people v. Montel Gatlin. Assistant Public Defender Ben Denowith appears and announces a referral for a forensic competency exam while the defendant states his name. On paper, this looks procedural, but the exchanges quietly foreshadow legal complications. What seems like routine paperwork actually sets the stage for the entire drama that follows. This is the quiet before the storm, where subtle words carry heavy weight. Stay with this part closely. It unlocks everything that's about to unfold.
All right, very good.
Mr. Simpson, what's going on here?
I'm sorry?
What's going on here?
Well, they've asked for a forensic evaluation. There's not. Well, Gatlin, just hold on a minute. I can't. Where it's requested by counsel, there's really not a lot I can do except to do the referral. Okay.
A forensics on what?
Likely for competency and criminal responsibility.
I'm just saying, what's their reason for trying to even do this just because I was trying to say something?
Well,
What's their reason?
no. I don't. Okay, so I'm not privy by design to all of the conversation that you have with counsel. You have conversations with counsel.
And still state what I wanted to state on record.
And I'm gonna tell you something, Mr. Gatlin. That would I just hold on a second. I don't know that would not only be a wise decision for you to come out and start stating stuff, but would also make me a bit concerned as to whether or not you understand the nature and objects of the proceedings. That is why I stopped it where I did the first time.
In this clip, the courtroom erupts into procedure versus intent friction. Counsel requests a forensic competency evaluation, and the judge reluctantly agrees, emphasizing the court's duty to follow defense requests. The exchange exposes cracks, counsel's urgency, the judge's measured skepticism, and the defendant's confusion, turning a dry legal motion into the first clear sign that this case will hinge on mental competency. This part teaches us how judges balance fairness against suspicion. Even though the dialogue feels procedural, tension builds steadily, making viewers wonder, is the defendant fit, or is this a strategy? It's a battle of tone and patience, setting up bigger clashes ahead.
And you're still in you're still in the same spot. And so your counsel has come out, they've asked for that. I'm gonna proceed to their request because they've made the request. So set a competency hearing date for September 9th, 2025, 9 a.m.
Mr.
Simpson, go ahead.
So you telling me they pushing my next court date all the way to September just because I wanted to come in here and take accountability?
No, I don't. No.
What's going on?
I don't think you should look at it that way because the two aren't necessarily connected that way. They're not trying to push your case. The problem, Mr. Gatlin, is you're trying to do things that may not be in your best interest.
It's in my best interest.
No, it is not. That is why that is why I stopped the proceedings when I did. It was clear to me that what you were trying to do was not part of the process and may very well be against your interest to just
take accountability?
In this segment, the defendant insists on taking accountability, but the judge repeatedly cuts him off, warning that such spontaneous admissions could harm his case. Counsel attempts to redirect, citing procedural protections. The judge's pause to explain competency concerns transforms an emotional plea into a pivotal legal risk, the moment where personal impulse collides with courtroom strategy. This is where emotion and law collide head-on, and the stakes suddenly feel real. You can sense the defense's struggle to protect their client, while the judge balances compassion with caution. Every word becomes a risk, and every second deepens the suspense.
It's clear you don't understand how this works, sir.
I'm being charged with some charges, and I was clearly just trying to take accountability for my charges.
And
That's
accountability can happen, but it doesn't mean that you load yourself up with everything that's there, which is what you were trying to do. And hold on, no, hold on. After, when we had Mr. Brown up there and I talked to Mr. Brown and Mr. Childers, Denowith, it's clear that there's an offer of some type.
I don't want to offer.
There's part of the problem. You're trying to, I'm done. Because you're not listening to it. You're just deciding you want to do something your way. I'm trying to explain to you why I'm doing it this way. I'm done. Bond continue.
That was September 5 year old.
No. Nine. Don't you dare leave this building without those orders for me to sign.
Yeah, I was gonna email them to a clerk.
Yeah, you better get them today. I want to sign off on them.
I'll go type it in the office.
I need to have a peaceful summer.
This clip shows the judge taking firm control. After repeated interruptions and a fraught back and forth, the judge declares he's done and insists on formal orders being submitted so the court can proceed properly. The moment deflates the defendant's impulsive approach and recenters authority. This is not just legal housekeeping. It's a reset button pressed in real time. The courtroom dynamic shifts instantly, signaling that personal outbursts will not carry weight here. The judge uses precision and finality to close the matter, reminding us that in court, order is everything. A sobering, decisive reminder that emotions bend before process.
Court does call the case, People versus Olivia Ray.
Conrad Solar on behalf of the township.
Good afternoon, Your Honor. Aaron Hilgendorf appearing on behalf of Olivia Ray, who's present. State your full name.
Olivia Ray.
Thank you. All right, what do we do?
Your Honor, we're here for an arraignment and a pretrial. For purposes of the arraignment, we have received a copy of the misdemeanor complaint. We went over it. We would waive its formal reading. Ask that you enter a not guilty plea on her behalf.
And in having waived formal reading, pleading not guilty, court will enter that plea.
Your Honor, it's my understanding today the defendant is going to plead guilty under Ida. She is 20 years old. So she qualifies for Ida. And so
Hold for one moment. You got him. All right, go ahead.
So it's my understanding she's going to plead guilty under Ida today. She's 20 years old. She wants to proceed that way.
That's accurate, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Go ahead and lower your hand. Say and spell your name out.
Olivia Ray.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud under the Pittsfield Township Ordinance. Your understanding?
Yes.
All right, that is a misdemeanor, punishable by up to 90 days in jail and a $500 fine plus court costs. Do you understand that?
Yes.
And understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
I'm sorry, can you repeat that?
You signed an advice of rights form,
Yes.
is that correct?
Yes.
All right. What'd you do at the Target store that makes you think that you're guilty?
I walked in and I exited with a face wash without paying for it.
With what?
A face wash.
Face wash?
Mhm.
Okay. Store was open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
No.
This property you took was offered for sale by Target?
Yes.
All right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor, we're satisfied.
All right, court will accept the defendant's plea of guilty to this charge.
In this clip, the court shifts to Olivia Ray's case. A 20-year-old acting student pleads guilty to retail theft after admitting she left Target with an unpaid face wash. The judge carefully explains the misdemeanor penalties, confirms she understands her rights, and accepts the plea. The exchange is procedural but undeniably human. Her youth, her remorse, and the fact that her parents sit behind her add texture that no legal transcript can fully capture. This moment balances punishment with recognition of potential. It shows how even small crimes carry weight, but can be a chance to change direction, not end a journey.
Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter.
June 25th at 9 a.m.
That works. June 25th, 2025, 9 a.m. You haven't appeared before me, obviously, before. Are you in school?
Not at the moment.
But yes,
Well,
normally.
yes.
She just finished her
Sorry,
second.
it's the summer.
Sorry you went to a second-rate school. It's okay, I'm a Maryland grad, so I have to just say that. All right. Go ahead, you were saying that. So
That's really it. We were going to ask for a personal bond, Your Honor. She's 20 years old. She is a full-time student. She's clearly off for the summer. She is taking this very seriously. Her mom's here right now. Her dad was here this morning. We were mixed up on the time, but he was here and had to take off. But he did take off work and he was here. She has taken a extensive theft awareness course. She took a 16-hour course. I presented Mr. Seiler with a copy of that. So based on that, I would ask for a personal bond, and then I got to notify you of one thing. Oh, actually, she has never mind. We'll be back before that. She has a wedding. Her uncle's getting married in Wisconsin, but that's going to be July 2nd. So we were going to ask for permission to leave the state for that.
what are you studying?
I'm an acting major.
Did you graduate high school here? In Ann Arbor?
No, sir.
Where?
I went to Interlochen Arts Academy. It's near Traverse City.
I know where it is.
Okay.
Everybody thinks I just crawl from under a rock and just put on a robe and come in. I know where it is. So that tells me that there's a lot of talent there. Right?
I hope so.
Valedictorian.
They know so. Right? So I'm sure your parents have probably asked you, what happened here?
I don't want to approach my statement with making excuses. I have had anxiety since I was born, really, but I was diagnosed with it when I was in 6th grade, and I was having a particularly difficult time, and I believe I just wasn't thinking and made a mistake.
In this extended exchange, the judge moves from formal adjudication to a direct, almost parental lecture. He probes why the defendant thinks she was caught, interprets her actions as inexperienced rather than malicious, and frames the incident as a youthful mistake. He mixes stern legal warning with empathy, highlighting mental health, the path forward, and that this episode need not define her life. The power here is in the tone, shifting from punishment to mentorship. The courtroom becomes less like a trial and more like a life lesson. It's gripping because you see law meet humanity in a way that feels rare and real.
Been doing this a long time, and so when young people particularly appear before me, sometimes I'm trying to figure out, why are you here? And why do you think you got caught? I'll let you answer, and then I'll give you the answer. Why do you think you got caught? It's a hard question.
Yeah.
I'll tell you why I think you got caught. I don't think you were raised to be a criminal or a thief in any respect whatsoever. You don't know how to commit a crime. That's why you got caught. Okay? And the important thing for you, just take a little bit of time, because I can tell when you walked up here, you were nervous as all could be, right? There's this crazy guy named Simpson up here, and there's no telling what he'll do, right? I bet you were asking your attorney over and over, what's he like? What's he gonna do? Am I gonna, right?
I mean, no.
No,
I
you didn't
Googled
ask
you, but
What'd you say?
I Googled you.
I'm not gonna ask you what you found anyway. You know, it's that day and age. If I want to know, I'm not asking my attorney. I'm just gonna Google it. Whatever you do, and you still got to go through the sentencing process and everything else. But I think it's important. You just finished your second year, and out of all of this whole thing, people at times make a lot of mistakes, right? And what you can't do is let this define who you are. There's not a person in this room that hasn't made a mistake that if they could go back, they'd like to do something different, right? But it won't define who you are. Okay? You got that? You didn't expect to have this conversation, did you?
No.
You're not crying, are you? What's wrong?
I just do when I get nervous.
Am I making you nervous?
Well,
Well, what?
I mean, the whole, not you particularly.
Just the whole thing, right? Okay. You'll make it through all of this, all right? You just kind of walk it through. There'll be some things for you to do, but it looks like you and your family got a head start on a lot of stuff. And you'll make it through. At some point then later in life, you'll look back, you'll try to figure out why the heck I did that, and maybe even get a little bit of a chuckle out of it in some way. Okay. So what kind of arts do you do?
A theater.
Your theater.
Mhm.
Really? So acting.
Yeah.
Probably good that you're with a bunch of lawyers. Seems all we do anyway, right? All right. Okay, young lady, you take care of yourself. All right.
Okay, thank you, Your Honor. And you just want me to give you a copy of that certificate from her class at sentencing? Or would you like a copy? I have
Well, I'll tell you what, on your way out, you can start the process. You can stop down at my probation department. They'll be on your left on the way down. And if you have a copy of the certificate, you could, if they'll take it right now, you can give it to them.
Okay.
Right now.
All right.
Okay.
Thank
All
you.
right.
See you on the 25th.
Yes, we will see.
In this closing segment, the judge softens and offers clear, personal counsel. He reassures the young defendant that mistakes don't define a life, instructs practical next steps, probation paperwork and certificate, and frames the incident as a learning moment. His measured warmth transforms a legal morning into a mentoring moment, leaving viewers with closure and a human takeaway. By the end, what began as a crime story evolves into a second chance narrative. The lesson is clear. Accountability matters, but redemption is real. If you like this breakdown, please like the video and subscribe. We'll see you in the next video.